Hello, I'd like to welcome you to the afternoon segment of our symposium here today. As Professor Robinson said, my name is Aida Alika, and I am the Associate Dean for Academic Affairs here at Washburn University. And I welcome you all. This afternoon is going to be much like this morning in that we will first hear from individual presentations from our panelists here today before we take a short break and then reconvene for a panel discussion and questions from you. We certainly hope that we can have a lot of dialogue this afternoon and that you engage with our presenters here today to expand all of our knowledge on the intersection between immigration policy, immigration laws, and the employment arena. Much has been made, of course, in terms of a lot of the dialogue on the immigration policies has focused on federal preemption issues, on constitutional questions, but we must not lose sight of the fact that a lot of the people that we're talking about here when we talk about implementing immigration policies are the people who we employ in our nation's workforce. And so the questions of whether certain federal employment laws themselves, like Title VII of the Civil Rights Act or the Fair Labor Standards Act, whether those laws themselves suggest that federal law does in fact preempt state law in this arena is an area ripe for discussion. But I won't bore you with my own questions or positions at this point, but we'd rather hear from our panelists here. First, we're going to have our own David Rubenstein here. David, we're very happy to have. He's joined us here for the second year, and he is an expert in both employment and immigration law. He's practiced in the field of immigration in the past and worked for let me get my bios out here. He worked for the Southern District of New York as a U.S. attorney where he specialized in immigration matters. He's also argued many cases in front of the Second Circuit Court of Appeals, issues of first impression. He's taught before coming to Washburn, he taught at Hofstra, where he also taught immigration and administrative law, and he continues to teach those subjects here. So thank you, David. Following David, we're going to hear from Juliet Stumpf. She is a professor of law at Lewis and Clark, and she also has depth in both employment and immigration matters, as well as the intersection of immigration and criminal law, national security law, and civil rights law. So we welcome Professor Stumpf. Rick Sue, who will speak last, is an associate professor of law and the director of law journals at the University of Buffalo. He has moderated and presented on many different workshops on immigration law, and he has authored numerous publications on the issue of employment law and local government law. So we welcome his expertise in immigration to end our panel this afternoon. So with that, I'd like again to remind you to hold your questions until the presentations are over and we open the panel up for discussion. Thank you.
Thank you. It was great hearing from Peter Vincent. Now, he made two suggestions that he was going to take Professor Reggie Robinson back to D.C., and I hope that Peter won't take this as the type of threat that he received when he was in Connecticut. But should he try to do that, he will have to deal with the Washburn faculty first. We're not going to stand idly by. First, I'd like to thank the organizers for inviting me to speak on this panel. That was a joke. And so in a debate that's as spirited as the one that brings us all together, I think it's really important to start with the common ground. If you were here for this morning's discussion, we can now appreciate that there aren't many grounds of agreement. The first general point of agreement, however, is that Congress is empowered to trump sub-federal, whether that's state or local, immigration initiatives. But that still leaves open the question, of whether or not Congress has exercised its trumping power. Easy answers to the question are frustrated on the back end because the statutes that Congress has drafted on the issue of preemption are not entirely clear. Meanwhile, answers on the back end are frustrated because the restrictionist laws at issue in these cases, like in Arizona and Alabama, have been drafted with the specific aim of eluding federal preemption. Thus, the undisputed principle that Congress can trump state and local initiatives still leaves open the question about whether or not Congress has exercised its authority to do so. The second general point of agreement is that the federal government should be managing migration, but that it's either unable, unwilling, or unsuited to do so effectively. But that still leaves open the question of whether or not states can compensate for perceived failures in the federal enforcement scheme, especially as those failures disproportionately impact the states with respect to things like safety, state economy, and health. The subject of the panel discussion is immigration and employment. My focus in particular is not on the general wisdom of the sub-federal initiatives in this area. Rather, my attention is focused at the threshold question of whether or not the current federal scheme constitutionally trumps or displaces these state initiatives. Now, last term, the Supreme Court in the Chamber of Commerce versus Whiting had its first modern crack at the issues in addressing the constitutionality of Arizona's 2007 Legal Workers Act. Its decision, which upheld Arizona's initiatives, will probably and should probably be only the first in a multi-part miniseries. My humble objective today, then, is to offer a description of the issues of the Court's holding and to suggest how Whiting might implicate or foreshadow the disposition of other immigration initiatives percolating in the states and in the lower federal courts. Now, regardless of how liberally or conservatively one reads Whiting's tea leaves, it seems to me that a majority of the Court sent at least one message, which is that states have some room to experiment with immigration controls and employment regulation in particular. But still, the question is how much. There's an important history behind the Whiting case that's necessary for understanding its holding and future implications. In some ways, that narrative traces back to our early history, when for about the first 100 years, immigration was almost exclusively regulated by the states. But in the interest of time, I'll fast forward to 1952, when Congress passed the Immigration and Nationality Act. The INA established a comprehensive federal regulatory scheme over immigration, including the terms and conditions of who could enter the country and who must be deported under what circumstances. What's important for the discussion, however, is that the 1952 Act did not expressly regulate the employment of unauthorized immigrants. In the early 1970s, states took it upon themselves to fill that void. In 1971, for example, California passed a law prohibiting an employer from knowingly hiring unlawfully present aliens. And these immigration employment laws were challenged in court on the grounds that they were preempted by the federal immigration laws. In particular, the challengers claimed that even though there was no federal statute on point, that Congress had exclusive control over the field of immigration. The issue came to a head before the Supreme Court in 1996 in Decanis. There, the court recognized two competing principles which are very much at the centerpiece of the dialogue today. The first principle announced was that the power to regulate immigration is unquestionably a federal power. The second principle is that states possess broad authority under their police power to regulate employment relationships within the states. The question for the court in Decanis there, which carries over to today, is which of the two principles applies? Stated otherwise, do laws that regulate employment of unauthorized aliens fall into the federal immigration law pale or into the state police power pale? In Decanis, the court placed the employment-related initiatives in the state police power pale. This result was owing in part to two important variables. The first one was that the court offered a rather narrow conception of what the exclusive federal immigration power was. In particular, the court identified the terms for exclusion and the terms for deportation as falling within the federal exclusive control. But under this narrow conception, not every enforcement law that targets unauthorized aliens is an immigration law, even if the immigration law at issue has the intent or the effect of deterring unlawful immigration. The second and important related variable was that at the time that Dukhanis was decided in 1976, Congress had not directly regulated the unauthorized employment of immigrants. That changed, however, about a decade later in 1986 when Congress passed the Immigration Reform and Control Act. It's this act that's the centerpiece of the Whiting case, and there's several interrelated parts of the law. The law starts by making it a federal offense for an employer to knowingly hire an alien who is unauthorized to work in the country. That is, the law targets the demand side of unauthorized employment. And to facilitate an employer's compliance with this new federal restriction, IRCA requires the employer to verify, reviewing documents, the employer's authorization to work, and to attest under penalty of perjury that the employee is authorized to work. This is the so-called I-9 process, which we'll talk a little bit more about later. Employers who violate these restrictions are subject to escalating civil and criminal sanctions. Notwithstanding the safe harbor afforded employers who comply with the verification process, there was a concern that employers would simply err on the side of not hiring people who look to be of foreign descent. And so in response to that, IRCA also created a provision which made it an offense for employers to discriminate based on citizenship or national origin. Finally, because IRCA was a direct response to state initiatives, like the one that was at issue in Dukhanis, and because Congress recognized that states had inherent interest to regulate the workplace, the Act expressly restricted the ability of states to do so in a preemption provision. IRCA expressly preempts states, any state or local law, from imposing civil or criminal sanctions upon those who employ unauthorized aliens. However, IRCA also contains this little savings provision here, to read that any state or local law imposing civil or criminal sanctions other than through licensing and similar laws upon those who employ unauthorized aliens. Fast forward again to the mid-2000s when efforts at comprehensive reform failed. States became increasingly frustrated by that and again began experimenting with their own enforcement solutions. The approaches that the states have taken are varied, as we heard about this morning. State and local initiatives directed at employment comprise one set of these potential solutions. IRCA, however, placed some restrictions on what states could do in this area, but at the same time it expressly left some room for states to regulate insofar as they were doing so, quote-unquote, through licensing and similar laws. In addition, IRCA arguably afforded states even more space because of what IRCA did not say. That is, the statute does not expressly indicate whether employees, rather than employers, could be targets of civil or criminal sanctions. It is this congressional silence that is the subject of other state initiatives that are directed at sanctioning the supply side of unauthorized work, which were not directly at issue in Whiting. So against this backdrop, Arizona passes its 2007 Act, building off the savings provision to provide that the state can suspend or revoke the business licenses of employers who knowingly hire unlawful immigrants. In turn, the law defines licenses quite broadly to include things like articles of incorporation, certificates of partnership, and grants of authority to conduct business in the state. The fallout is that for employers who hire unlawful immigrants, the state retained the authority to suspend all of the ability of the state to do, the corporation to do business in the state. In addition to this, Arizona law also required that employers use the federally administered E-Verify program. Now, Juliet will talk some more about the program, but in short, it's an internet-based system that allows employers to verify the work status of potential hirees. While the federal statutory scheme provides that E-Verify will be voluntary, the Arizona scheme made it mandatory. And so both the mandatory e-verify and the suspension of the license provisions were challenged in court by a number of groups, including the United States Chamber of Commerce, on the grounds that they were preempted by IRCA and the federal e-verify provisions. The Ninth Circuit upheld the law against constitutional attack, and the Supreme Court granted cert. Now, before getting to the Whiting decision, a basic understanding of the Court's preemption doctrine is necessary to understand the Whiting holding and its implications. Preemption starts with the Constitution's Supremacy Clause, which provides in relevant part that the Constitution and the laws made pursuant thereof are supreme over state law. Now, there's much room to argue, and indeed it has been argued, that questions of preemption really turn on normative or ideological assessments of where the line should be drawn between federal and state power. Still, for all its limitations, there is a judicial preemption doctrine, and at least outwardly, it is how the Court frames and addresses these issues. The Court's doctrine recognizes two general categories, and for those of you who are visual learners, I hope this will help. There is express preemption and implied preemption. Both types of preemption, whether express or implied, are said to turn first and foremost on congressional intent or statutory interpretation. Express preemption occurs when a federal statute explicitly withdraws state power, like IRCA's preemption provision that was at issue in Whiting. Implied preemption likewise turns on statutory interpretation, but unlike express preemption, the requisite congressional intent is not found in a preemption provision, but rather in the surrounding substantive statutes. Now, implied preemption comes in several flavors. First, a state law is so-called field preemption when Congress enacts sufficiently pervasive and detailed legislation targeting a specific type of conduct, such that the court can infer that Congress intended to occupy the entire field to the exclusion of the state. Second, implied preemption can occur in the event of a conflict between federal and state law. In turn, conflict preemption comes in two flavors itself. The first is obstacle preemption, which occurs when a state law would impermissibly frustrate the accomplishments of a statutory purpose or objective, and the second is impossibility preemption, when it would be physically impossible for a party to comply with both federal and state law. For example, if the federal law provided X and the state law provided non-X. Now, distinguishing between these different types of preemption can be difficult, but they usefully reflect the various ways that state law can be preempted. And as I mentioned at the beginning, they tend to provide a useful framework for addressing preemption questions. Okay, turning to the Whiting decision. As I noted earlier, IRCA expressly preempts any state or local law imposing civil or criminal sanctions other than through licensing and similar laws. The first question was whether or not Arizona's laws calling for the suspension and revocation of business licenses fell within this parenthetical saving provision. A majority in Whiting, which was comprised of Chief Justice Roberts and Justices Scalia, Kennedy, Thomas, and Alito, held that the statutory term licensing was broad enough to encompass Arizona's law and thus saved it against express preemption. Applying a quintessentially textual approach, the majority propped up its broad reading of the term with definitions of it found in the Administrative Procedure Act and in dictionaries. The Chamber, of course, unsuccessfully argued for a narrower interpretation of the Savings Clause, and without getting into the gory details, it argued from statutory context that when Congress referred to licensing laws, it was referring to the regulation of state licenses given to a particular type of employer, specifically to farm labor contracting companies. And the Chamber may have been onto something with this argument, and indeed Justice Breyer in dissent espoused it. But the majority in Whiting rather brusquely dismissed this contextual claim and critiqued the Chambers for reading the term licensing in a way that was not even remotely discernible in the statutory text. And so while leaving open the possibility that contextual arguments might help resolve an ambiguous statutory phrase, the majority in Whiting was simply not prepared to use such a contextual argument to create rather than to solve an ambiguity. Moreover, the Court's reaction to the Chamber's attempt to use legislative history suffered the same fate. While leaving open a question of whether legislative history is ever a legitimate or ever a reliable basis for interpreting statutory text, the Court said it would not be used here to create an ambiguity that otherwise did not exist. So the Chamber's express preemption challenge failed because it was saved by that parenthetical language. But still remaining was whether or not the Arizona law was impliedly preempted. The Chamber argued that notwithstanding the fact that it wasn't expressly preempted, that it nevertheless could be impliedly preempted through the surrounding statutory scheme at issue. And again, the court disagreed, finding that there was no conflict preemption. What may ultimately prove to be an important passage as it relates to the still looming questions of other state initiatives, the court had this to say. Do I have a slide for this? No. The court had this to say. Arizona went the extra mile in ensuring that its laws closely tracks ARCA's provisions in all material respects. In this regard, the court highlighted four things. First, that the Arizona law adopted the federal definition of who qualifies as unauthorized aliens. Second, that Arizona law required the state to defer to the federal government's determination of whether or not a particular individual was authorized to work. Moreover, both the Arizona law and the federal IRCA required that an employer could be sanctioned only for a knowing violation. And finally, like IRCA, Arizona law provided affirmative defenses and safe harbors for those who complied either with the I-9 verification process or E-Verify. The tracking of federal standards is a staple feature in a great number of the state initiatives that are percolating below. That the court gave great weight to this tracking element in this case as a saving grace can prove to be an important victory in upcoming battles for the restrictionist states, especially since, as Justice Breyer emphasized, there's at least two important differences in the federal and the state schemes. The first is that they have different enforcement procedures and that the state enforcement procedures were potentially more burdensome. But also, and importantly, the Arizona law did not contain an anti-discrimination provision. Relating to this last point concerning the absence of an anti-discrimination provision, the court addressed the Chamber's argument that the law presented an obstacle because it somehow upset the balance that Congress intended in IRCA. The delicate balance in the Chamber's view sought to accommodate three things. Number one, to deter unauthorized employment. Number two, to avoid undue burdens on employers. And number three, to guard against discrimination. Included in the Chamber's argument was the concern, echoed in Justice Breyer's dissent, that the Arizona law amounted to essentially a business death penalty, and that given the draconian nature of the sanction, employers would simply err on the side of discrimination, that is, by not hiring anyone that appeared to be of foreign descent. But again, the court was not convinced. The majority did not seem to deny that Congress sought to strike a balance in IRCA, but the court did not accept that Arizona law upset that balance in ways that Congress had not at least contemplated through the licensing laws. In this regard, the court said, the balancing process that culminated in IRCA resulted in a ban on hiring unauthorized aliens, and the state law here simply seeks to enforce that ban. Next, the court turned to Arizona's requirement that employers use the federal E-Verify system. The Chamber had argued that it was impliedly obstacle preempted. In short, because the E-Verify system that Congress wanted to develop was voluntary, and again, the Arizona initiative made it mandatory. Again, the court began its analysis looking at the statutory text and found nothing in the statutory text which prohibited states from making the system mandatory, even though, at least as to the federal government, it was only voluntary. Indeed, the court was quick to point out in 2003 that Congress instructed the Department of Homeland Security to make E-Verify available in use in all 50 states and to actively promote and encourage its expanded use. So at the end of the day, all of the preemption challenges failed in Whiting. So what's in the tea leaves? Now, as I noted at the outset, there's room to argue that while the court's preemption doctrine speaks in the language of congressional intent, At the end of the day, these preemption determinations often turn on value judgments about where the lines between federal and state authority should be drawn. I'm not prepared to say that Whiting sends any resounding messages in favor of sub-federal restrictionist immigration initiatives. But I do think it's fair to say that the decision, if it points in any direction, is toward accepting a state role in immigration. Though the Whiting decision dealt with while the Whiting decision dealt with the express preemption and savings clause, it also entertained the Chamber's implied preemption challenges. And the Court's rationale for rejecting the implied preemption claims could very well be telling or relevant for some of the future challenges that are likely headed to the Court. First, the Court seems to have embraced Dukakis's narrow conception of what immigration law means. Immigration law, at least that aspect over which Congress has exclusive control. Whiting affirms that Congress has exclusive control over the admission and expulsion of immigrants writ large, but not every law that impacts or touches upon immigrants is left to the exclusive federal domain. And so field preemption claims look to be a little harder than they might have been prior to the decision in Whiting. Now, absent field preemption, implied preemption challenges were either going to have to be based on impossibility conflicts or obstacle preemption. And again, because the drafters of the laws took such great aims to avoid preemption, I'm not aware of any instances or any arguments being made that the laws are preempted because it's impossible to comply with both the federal and the state laws. And so what remains is obstacle preemption. And this is a rather bedeviling concept. It will be found to exist when a state law gives rise to an impermissible obstacle to the achievement of a federal statutory objective or purpose. So there's much flexibility in the joint of obstacle preemption. The first is the question of determining what Congress's purposes in a statute was, which in turn gives rise to issues about how much weight, if any, to give to atextual evidence such as legislative history and the like. Moreover, once that purpose is identified, the Court has to make what's essentially a value judgment of whether the state law by degree impermissibly conflicts with that purpose. It's generally this malleability, which is a lightning rod of criticism for obstacle preemption. There's just too much room for the Court to decide what's preempted. And as it relates to our discussion today, the Whiting majority seemed sensitive to these concerns when, in rejecting the Chamber's obstacle preemption challenge, it said the following: implied preemption analysis does not justify a freewheeling judicial inquiry into whether a state statute is in tension with federal objectives. Otherwise, the process of judicial review would undercut the principle that it is Congress and not the courts that preempt state law. My point is not that obstacle preemption is off the table. Rather, my points are twofold. First, that the fate of almost all of the percolating state initiatives hinge on how liberally or conservatively the Court will apply the obstacle preemption doctrine, and that the trend appears to be moving in a more conservative direction. Thank you.
Well, I'm in the unenviable position of being sandwiched between one of the national experts on preemption and one of the national experts on state and local government. So fortunately, he's gone out of the room at least. I'm going to do my best to act as peanut butter and see how that works, right? So, but I want to start simply by saying thanks very much to a couple of people, Sean Lysander, the Washburn staff, and the staff of the Washburn Law Review, who've been incredible hosts. They've certainly shown Washburn hospitality, and they've also really showcased the quality of the law students here. And I have to say that the amazing quality of this conference reinforces the old adage that if David Rubenstein builds it, they will come. So the title of my talk is Getting to Work, E-Verify and the Democratic Enforcement of Immigration Law. But it really should be called something like why nobody cares about E-Verify, but probably should. So let me introduce, David did me the favor of introducing the E-Verify system a little bit, but I want to tell you a little bit more about it. As he said, E-Verify is basically an electronic verification of whether an employee has authorization to work in the United States. And basically what happens is that, at a point of time when an employer hires an employee, that employer provides the information, driver's license or passport information or Social Security information, to a federal government-run database that checks that employee's information against Social Security, the Social Security Administration database, and some Department of Homeland Security databases. So what happens then is, right, most of the time, right, the information runs through the system and comes back and confirms that the employee has work authorization. But sometimes it doesn't, right? And it comes back with something that the computer calls a tentative non-confirmation of work authorization. How's that for government speak? And then, there's some checking that happens after that point in time. At that point in time, when the employer receives that tentative non-confirmation, the employer is then supposed to provide that information to the employee, and the employee then has 8 days to contact the government agency. And it's usually either the Social Security Administration or the Department of Homeland Security, right? And the employee is then supposed to go to that agency and try to fix the problem. So, if through that process the employee isn't able to to fix the problem, the system comes back and tells the employer that there has been a final non-confirmation of work authorization. Now, the other time that a final non-confirmation of work authorization can come about is if the employee doesn't contact that government agency within 8 days. So there's basically 2 ways for that final non-confirmation to happen. And at that point in time, the employer is expected, though not forced, right, by the government, is expected to terminate the employment of the employee. Okay, so the way that the government has set this up, this started out as a pilot program. I worked on it very briefly when I was with the Justice Department on the civil rights side of things. But the way this was set up is that it's a voluntary program, as has been mentioned before. But I want to make one thing clear about the idea of this being a voluntary program. The federal government has said to employers, right, we're making this system available, and you're welcome to volunteer to become one of our E-Verify employers. And then the states, some of the states, as you know, have mandated the use of that system. The one thing that I want to make clear is it's not a voluntary program for the employees of the employer once they decide to participate in that program, because the employer signs a memorandum of understanding with the government that says, I promise to run all of my new hires within 3 days through that system. So I would consider it sort of mostly voluntary for employers, not voluntary for employees. Okay, so as I said, right, we've seen this trend towards states mandating employer use of E-Verify, and they've done that, in a couple of different ways. Either by mandating public employer use. Some states have mandated that all private employers must use the E-Verify system. But there's been a small counter trend. Illinois at some point said, we're not going to permit any of our employers to use the E-Verify system. And a district court said, actually, that's preempted. I can't do that. But California has done something different relatively recently. They said, municipalities, you're not allowed to mandate that your employers use the E-Verify system. Right? It's a sort of different counter trend, sort of a counter trend away from the mandating of E-Verify. Why is this important? Why is what states do important? Well, one of the reasons is because what states do, right, can affect what the federal government decides to do with the E-Verify program. The federal government has to decide, and is sort of in the process of thinking very deeply about whether to make this a nationwide mandated program. Right? And what the states do, if there's a strong state trend towards mandating E-Verify or a strong state trend the other way, right, that's going to affect what the federal government's decision is as well. So what we know from David's presentation is that the Supreme Court has said that, right, suggested this is something states are allowed to do. So how should states go about deciding what to do about E-Verify and which trend to follow? So before I address that, let me just talk for a minute about work, about the way that we think about work. We think about employment, generally speaking, as a private arrangement between employers and employees, right? We think of employers as the ones who are the gatekeepers of access to employment, to the workplace. Right? They decide who may become an employee, right? Who to hire and who to fire. So we tend to think about work as a private relationship, right, with government essentially on the sidelines. And I would say even, I think we tend to think about government's role in the workplace as often one of protecting the employee through the kinds of laws that Aida mentioned, Title VII, employment discrimination laws, state laws as well, wage and hour, etc. So that's the realm of employment law and employment discrimination law. But if you wander over into the realm of immigration law, right, the role of government looks very different. Government has always regulated access to employment on the immigration law side, right at the border or through immigration admissions policies, right, and down to quite a level, right. We know that, for example, foreign students who are on visas for studying in the United States, the federal government has said you get 20 hours, right, to work per week. So the federal government has a huge, very deep role in regulating the workplace and regulating that relationship between employer and employee. Okay, so what I want to do is bounce off a little bit of what David talked about before. IRCA, the Immigration Reform and Control Act, I think really introduced the government into the mainstream of that employer and employee relationship into the workplace. Right? It created the employer as the immigration screener. It's a sort of a new role for the employer. The collector of immigration records in case the government wanted to later come back and ask for those records and do some immigration enforcement through the workplace. Right? So I think E-Verify takes a further step with this. I actually see E-Verify as kind of a Cheshire cat. The government has now become a very active part of the inception of the employment relationship for everybody, not just for immigrants. I think the employer sanctions that Immigration Reform and Control Act is very much seen as an immigration law. I think E-Verify is seen as an immigration law. But I think what it really does is it brings the presence, that government presence into the individual decision, every individual decision about whether individual employees have access to employment with that individual employer. Right, so E-Verify's role here is to increase and make obvious that government role as a gatekeeper to access to employment, something that we saw, right, that the employer really doing. But as I said, right, it's still seen as an immigration problem, not really relevant to U.S. citizens. This is what I mean by nobody cares about E-Verify. Right, the majority doesn't tend to really pay a whole lot of attention to it. A lot of people, when I tell them what I'm writing about, they say, "What's what E-Verify? What's that? Remind me." So what I want to do is lay out a couple of the objections that others have raised to the E-Verify system, and then I want to talk about what brought me here. Okay, so some of the objections to the E-Verify system, one is that it's ineffective, it doesn't do what it's supposed to do, and it does other things that it's not supposed to do. Right, so some people have said, well, it fails to catch undocumented employees when they present somebody else's valid documents. So what we see is that the system confirms the work authorization of 54% of undocumented immigrants. But it also, on the other hand, fails to confirm the work authorization of people who do have the right to work in the United States. So right now, or actually I think it was in 2009, 2.6% of these cases get these tentative non-confirmations. And so we have a pretty small rate of tentative non-confirmations. Right? But within that number of non-confirmations, somewhere between 22% and 95%, depending on which study you look at, are erroneous. Right? So that they are actually employees who do have work authorization, and the system is getting it wrong. Now, the errors don't fall evenly on everybody. They tend to fall on basically on minorities and ethnic minorities in particular. U.S. citizens with foreign names, naturalized U.S. citizens, some legal immigrants, and people who have, through marriage or for some other reason, have changed their names and failed to inform the government about that change. So that's one of the objections. The other one is that E-Verify could be used or has been used as a tool to disrupt labor organizing or some other kind of employee organizing in the workplace. Right, that the employer now has the ability to use E-Verify to get information about employees and then use that in wage negotiations or labor negotiations, right, through strikes. And the third one is that some people simply have an objection to too much enforcement against undocumented immigrants. Right, the belief that because the fact that somebody's working, even though they don't have legal status, that we shouldn't go after undocumented immigrants in the workplace. Okay. My interest is a little bit different. I'm interested in how E-Verify sheds light on two challenges that democracy faces. Right. One is how can government decision makers, right, Congress, the federal agencies, courts, but also states, right, how do they get it right with E-Verify when the harms fall on a minority? Right? And that's a problem inherent in democracy, right? That's the whole idea that the majority rules, right? So how and when do you protect the minority? When should courts rein in right, the decisions that states and the federal government makes, i.e., for example, through preemption, right? That's one way to do it. The late Derek Bell, Professor Bell, has suggested that a theory called interest convergence. When the interests of the minority line up with the interests of the majority, that's when legislatures and courts are most likely to act to protect the minority. And Hiroshi Uemura has said something similar. When you're making arguments about the rights of non-citizens, right, those arguments are most persuasive when those rights align with the interests of citizens. Right, the arguments for immigrants become more compelling. Right, so that's one of the questions that I have. And the second one is how, right, if that's true, and there are interests of the majority that are implicated by this E-Verify system, how do we protect those interests? And we usually look at our states, our legislatures, and our courts, but particularly legislatures, I think, and we ask them to weigh the costs and benefits of implementing a particular policy. So let me lay out the benefits of the E-Verify system. Right, one certainly is the idea that it's supposed to increase the enforcement of immigration law, basically do a better job. The other one is actually that it's intended to reduce discrimination, right, by giving the employer more information about who is work authorized. Right, it's sort of a race-neutral, ethnicity-neutral information from this government database. Right, it's a better source of information than somebody's appearance or accent. Right, but as we know, E-Verify also poses some risks to U.S. citizens and lawful immigrants, and those are the ones that I'm interested in. One of those, as I talked about before, is the risk of error, that the E-Verify system might get it wrong for people who do have work authorization. The risk of misuse by the employer, that the employer might not provide that tentative non-confirmation to the employee because they don't want to continue to pay them during that time that the employee is figuring it out, when so many of those tentative non-confirmations are going to turn into final non-confirmations and they have to fire that person. Right? The risk as well of future misuse of the E-Verify system by the government, I'll talk about that in a sec. My problem is, I think these risks, these potential costs, are very difficult to evaluate. Right? So take the risk of error, for example. From the individual U.S. citizen's perspective, right, it doesn't make sense to care about E-Verify. Right? That risk of a tentative non-confirmation of the system getting it wrong, it's low. Right? And a final confirmation is even lower. Right? But if the system does get it wrong, the cost is somewhat high. Right now we know that the average time it takes to straighten this sort of thing out is somewhere between 7 days and 12 days. That it costs some time, just the employees have to actually take time off to go to the government agency. There's often some cash involved in straightening out their documentation. At worst, right, there's the job loss. If there's an erroneous loss of job. But looking at it right now, right before the E-Verify system is in place, or before your information is run through that system, right, the risk seems pretty low. Not going to happen to me. But when you aggregate that risk across the entire working population of the United States, right, we get to a much larger number. That's not really a number that individuals can pay a lot of attention to. Right, so what we end up with is very little individual incentive to oppose the system or to gather up others, right, or protest against the system. Right? Who is responsible for aggregating that risk, right, and addressing it? And I think, well, tort professors might say, well, tort lawyers are supposed to, right? That's what class actions are for, and that sort of thing. But I think most people would say the government, right? That's how we got FEMA, for example. The government is supposed to figure out how to aggregate risk and protect us from these sorts of things. And my concern is that when the states are deciding whether or not to mandate E-Verify, that these costs are incredibly difficult to evaluate and therefore might be underestimated and undervalued. So let me lay out a couple of these risks to the majority interests that go beyond the ones that I've already mentioned, because I think these ones are particularly hard to quantify. First of all, E-Verify heralds a new way of conceiving of the workplace. Right? This is the idea that we have to receive permission from the government as part of the employment process. That's not part of our current national consciousness. Right? I think also that E-Verify kind of normalizes the role of government in using the access to the workplace as a legitimate location for law enforcement. Right? Outside of immigration enforcement, when the government steps into the workplace, right, it's usually, I think, on the side of the employee, except maybe for taxes. Right? But it's in the form of these employment discrimination laws, etc. So when the mainstream employee's perception of the workplace as relatively free from government coercion, right, meets up with this comparatively coercive government-centered framework from immigration law, I think the nature of the workplace changes, and that the role of the government becomes very visible when employment encounters immigration enforcement. Now, third, E-Verify provides a new role in immigration enforcement to a set of quite powerful actors. Those are the states. Right? So this growing tendency, this growing trend for the states to mandate the E-Verify program is a pathway, I think, for the states to claim a greater role in social control of migrants and others through this larger presence in the creation of the employment relationship, something they didn't really have much of a role in previously. I'm going to raise one final potential harm, and I think this is even more difficult to evaluate because it raises a future contingency. So Professor David Cole has written before about how immigration law often acts as a wedge for the government curtailment of mainstream liberties. So the role of the immigration agencies in charge of E-Verify, right, that's their job as immigration enforcement. But the mission of the Department of Homeland Security is broader than that. Right? Its central focus is national security. And what E-Verify provides to Homeland Security is information about every U.S. employee, right, who passes through that computerized system. And it may be tempting at some point, at some future point, to use that information for purposes that go beyond immigration enforcement. Now, these harms, I think, are unquantifiable. They follow also only indirectly from implementation of E-Verify. I also think identifying these harms doesn't necessarily answer the question of whether E-Verify should remain a voluntary program or become something national, right, or even statewide. But they are, I think, factors that need to enter into some of the national and state conversations we're having about what to do with the E-Verify program, because they have such a widespread effect on the population of U.S. employees. Right? So that naming these harms makes clear that E-Verify is not just an immigration enforcement program, but it's an entryway for law enforcement to play a greater role in the workplace. I'm going to say just one more thing about work. Right? Work plays a central role in our society. It generates income to sustain ourselves and our families. Right? We buy goods as a result of work. We can buy goods. We can enhance our leisure time. Work also has social and personal meaning. And I think we should just be very careful about how we allow the government to use that delicate moment where work begins. Thank you.
So it's always hard to be the last speaker on the last panel of a long day. So I'm trying my best to keep everyone awake. If I don't entertain you with my ideas, maybe I'll just speak louder and wake you up. I first want to start out by thanking everyone at this conference. I think we've had a really exciting conversation. Hopefully we will continue that subsequently. It really is an honor to be invited to join this conversation. And I really need to thank the faculty and the students at Washburn Law School. They've really given me a warm welcome. It's my first visit to Kansas, and I am loving it. It's also sunny, which helps. So, following the theme of the panel, what I do want to talk about is the intersection between labor and employment laws on the one hand and immigration laws on the other. But I want to take a little bit of a different perspective. Rather than focusing, as my fellow panelists have done much better than I could have, on specific cases or a particular regulatory regime, I want to try to experiment, take a step back, and look more generally about the connection between these two bodies of law, not only what we're experiencing right now, but historically, right, and how it has evolved. I also want to take a little bit of a different approach than what most immigration scholars have done. Most immigration scholars have focused primarily on how immigration affects employment conditions or labor markets within the United States. What is often missing, I think, here is a richness or robustness of the world of labor and employment law, which, for those of you who may be familiar, is also quite contested, quite conflicted, and have gone through different evolutionary trends. So what I want to do here is sort of reverse the presumption. I want to actually start out with a history of labor and employment law. And what I want to argue here is that actually there is no comprehensive, cohesive system to be talked about. Oftentimes in immigration opinions and immigration talks, we talk about labor and employment as a sort of one big monolithic thing. But I want to show that actually through history, sort of arising out of it, there are actually three competing models of how we think about approaching labor and employment. Now, I do have to say at this point, what I'm concerned about is not necessarily how we substantively balance different interests, right? What I'm not concerned about, I'm not necessarily concerned about the substance of the law. What I'm sort of focusing on is different approaches with regard to what we view the role of government in striking a particular balance to the extent that we agree on it. In the second part of my talk, I will then take those models and use it as a lens of exploring the development of immigration law more generally. I want to say that it actually does and goes a long way in explaining a lot of the historical developments of immigration law, including some of the current debates that we're having today. And third of all, and this is the thesis of my talk, I want to suggest to you that actually a lot of the conflicts and debates and tensions within the immigration law itself isn't specifically or narrowly tailored to immigration. That actually, in order to resolve these conflicts, what we really are working through and resolving is some of the conflicts that we're having about how labor and employment should be regulated as a matter of governmental role, and through that has informed how we've approached immigration and how we talk about it. Okay, so first I want to turn to the world of labor and employment law. Now, I am no expert, and I will probably be schooled in several regards, but I do think I can present a broad history and offer to you broad models of what I think is going on. It is often, like I said before, portrayed as a comprehensive or cohesive system. But what I actually see within the law itself is actually three distinct approaches, which I will document here. Now, I've thought about different ways of presenting this. I have one way of starting out. Hopefully it'll work. If not, wait for the second half. I'll make it all clear. So what I actually want to start out with is 3 pieces of seminal legislation that was passed by Congress in the 1930s and 1940s. I hope I didn't lose your attention already. Okay. The first was the Wagner Act of 1935. For those of you who don't know, the Wagner Act essentially set up a government process by which by which unions and employers would be able to negotiate in a process of collective bargaining. The second legislation I want to talk about is the Fair Labor and Standards Act. That's 1938. This actually set up what we now know as the federal minimum wage and the 40-hour work week. The third law that was passed in 1946 was the Full Employment Act. And what that said was that it committed to the federal government the responsibility to ensure that there was employment within the United States. But the means by which they would do so was primarily through trade policy, monetary policy, and maintaining a trade balance. Now, all these were actually enacted in response to the Great Depression, and they were all enacted as part of the New Deal. So for a lot of people, they like to approach this as one big package. But if you haven't already seen, what I want to suggest is within these 3 laws actually exposes 3 completely different ways of approaching issues of labor and employment from a governmental perspective. First, on the one hand, what is different about these laws is that actually they all operate at very different levels of the economy, right? The Fair Employment Act assumes that the government acts at the international national level. The flow of capital and labor and products from one area to the next, and that is through that we indirectly set employment and labor policy in the United States. The Wagner Act, which is about unionization, assumed that actually what is at stake is at the organizational level, between firms and collective unions, right? And that the process by which the government participates is in regulating that relationship. And the third law, the Fair Labor and Standards Act, actually operates at the individual level. It goes forward and actually sets substantive requirements with regards to what an individual is guaranteed with regards in the world of employment. What I want to say about this is not necessarily that they're just sort of 3 different levels, but they actually also correspond to 3 different periods within labor and employment practices in the United States. The Wagner Act, as you all know, was pivotal in sort of kickstarting a broad period of time from the 1930s to 1960s when labor and employment practices was essentially seen as an area of law about collective bargaining. Right? It was an area of law by which we imagined that the federal government wasn't going to step in and ensure that everyone has specific rights or what you have, but that it was through private bargaining of 2 parties that they were going to negotiate the terms of what would be good, fair wages, good labor conditions, and good employment overall. And in fact, over the years, we saw in many ways various benefits and various programs that in other countries became governmental programs. In our country, actually evolved out of collective bargaining agreements that essentially became tied to the employer, such as health insurance. There are a lot of benefits to, I think, what a lot of individuals saw with regards to the Wagner Act and collective bargaining. For the most part, it said that the government didn't necessarily know exactly what was best for employers and employees, and that it was up to them to dictate and settle whatever those scores was. But it did state that the government was obligated to step in and negotiate to ensure that there were equal playing grounds on both sides. In fact, Mark Eisner called this period of time, interestingly enough, a period by which the government was focused on government-supervised self-regulation. But there are also costs to unionization, and I don't want to go through all of them now. There is obviously the cost that this is not really about the individual, that the union itself is more of a collective entity that is more dangerous than employers in some regards. And there were also concerns, and as we see later, that unions were not actually representing all the rights that employees were concerned about. This specifically had to do with a lot of minorities and, at that time, gender. The Wagner Act represented I would call, a middle-level way of approaching labor and employment through organizations. The 1960s and 1970s witnessed another revolution in labor and employment law, and I think this is the one we're most familiar with today. During the 1960s and 1970s, along with the Civil Rights Act, there was also a broad transformation in how we saw labor and employment. The federal government became much more involved in saying, we don't want just private bargaining to associate the terms. We want to actually step in and dictate those terms themselves. We had, in many cases, Title VII with regards to racial discrimination and saying that every one of us has a right not to be discriminated in that regard. That later gets expanded to gender, also expanded to disabilities, and also parental status. We also had the establishment of OSHA, right, Occupational Safety and Health, that said that it wasn't up to collective bargaining to determine whether you had safe working conditions. The government, through obviously bureaucrats and technocrats, will decide that, and through that process enforce it. Now, what's interesting about this transformation is that not only did it shift the focus from an organization level, it shifted it down to an individual level. And we begin to see labor and employment not as a structural issue, but as an individual rights issue, right? Much like the civil rights itself. So a lot of the basis under OSHA, a lot of the basis in discrimination is not that we collectively protest something, but as an individual, I protest, and I fight it out in court and administrative hearings, and it's on a one-on-one basis. Now, overshadowing all of this, which I believe never has gone away, is also the belief that actually the government's most appropriate role, especially the federal government, is really at the level of macroeconomics. We shouldn't be dealing with firms and organizations or trying to guarantee things with regard to individuals. The market will work all that out. The government's main role is to make sure that as a nation, right, all the conditions to a good, healthy market exist. Right? We want to make sure we don't have crazy trade deficits. We want to ensure that trade deals that we negotiate with other nations are fair. We want to ensure it through regards to monetary policy. And I will explain later, in some regards, immigration is a part of that, right? Because it dictates the flow of labor from one nation to another. What's interesting about this part is it actually has a long history, right? We often see the federal government as well suited to be able to guard its borders and control the flow of individuals and labor and capital and goods from one area to the next. But at its core, it actually is a much more distant perspective of what the federal government should do with regards to labor and employment than the other two models I laid out before. Okay? So to summarize again, I've laid out three models, I think, of labor and employment that actually not only correspond with specific eras, but are actually quite distinct within the debates today. A broad level macroeconomics argument to say that the government really should just be regulating broad economic conditions. A middle-sized level to say that the government should be facilitating bargaining among organization of firms. And an individual level to say that the government should in fact step in and guarantee specific individual rights. Okay? Maybe too long of a digression, but let me bring it back to how this relates to immigration law. What is interesting about how we talk about immigration, and I think you already sensed it a little bit before, is to the extent that labor and employment are important in immigration, we often see a way of regulating immigration, which is essentially a government activity, as a means of resolving our labor and employment conflicts. But because there are actually different models with regards to how we approach that issue, the immigration law has also changed in response to that. Here I want to talk about the connection in three ways. The first, I want to talk about how it relates to certain historical developments, and it gives you a certain historical frame of why immigration regulations developed the way it has. Second, I want to actually bring it down to level and talk about current developments, right? The arguments and debates we're having right now about how to reform our immigration laws. And third of all, I will talk a little bit about how this also informs a little bit about the conflict that has historically been at place, but also at place today, between the federal government and the states with regard to immigration. Okay? Let's start with history. So what is interesting in this regard... It's actually interesting to see that as we have evolved with regards to the government's role in labor and employment, we also have seen similar interesting shifts within immigration law. Now I'm going to present something real superficial at this point. We've already heard from Peter earlier about how ICE within the Department of Homeland Security is regulating immigration. It may be unknown to you, but actually throughout history, immigration has been allocated to several different governmental agencies. It actually started out in the Department of Treasury, before it got allocated to the Department of Labor, and then in 1940 got transferred to the Department of Justice. Now, in some ways, this doesn't match up exactly, but I want to suggest that what was going on was that throughout these eras, we had different ideas of how immigration affected labor and employment as a matter of macroeconomics, as a matter of labor and firm organization, as a matter of individual rights, and as a result, this corresponded to how these agencies changed. But I don't want to just rely on that, right? I want to actually go into the substance of the law. The fact of the matter is, when at a period that we really saw the government's role, especially the federal government's role, as merely regulating inflows and outflows, we actually also saw an immigration system that really treated the immigrant as an article of commerce. During the mid to late 19th century, almost every single immigration regulation at the state and then the federal level had to deal with head taxes. Right? How much an immigrant had to pay in order to enter the country, which, if you treat it like an article of commerce, really not like the tariff system that we set. Do you raise the head tax and therefore make importation labor more expensive? Do you lower it and make it cheaper? How do you adjust it in order to have the right balance? Along with that, it's interesting, is that although we saw the federal government as mostly involved in trade negotiations, right, making trade deals with other countries, early immigration regulations also corresponded to that as well. Now we think about immigration regulations as what we do at the borders, but during this time, most of the deals were actually struck with other countries. We made specific treaties with Italy, with China, with Japan, about how many people they can send, who they can send, and who will accept. Much like we bargained, as we did recently, about fair trade with regards to how goods and services will get traded between different countries. In fact, it's interesting to note that this is way before some idea of substantive rights, but the early immigrant opposition to state immigration regulations often appealed to the fact that there was a treaty in place and that as an article they were protected by this treaty. As labor relations became the primary mode of how we talked about labor employment, you also saw a shift in how immigration was regulated. I see I'm a little short on time, I'll go a little bit faster. One thing that's interesting is that instead of just regulating broad numbers, you saw seeing the federal government much more concerned about the labor relationships that immigrants had once they arrived. The Padrones Act and the Contract Labor Act really tried to address the question is, are these immigrants who are coming actually free labor? Are they actually sufficiently detached from their employers in order to play a strong role in negotiation on both sides? Or are they bound, like a indentured servant in some regards? We also saw the terms of the immigration debate starting to shift as well. And started talking about sort of broad macroeconomic arguments. We had actually, in this time, labor and employment making various different arguments about immigration. And in fact, the fact that we cut off immigration in the 1920s on the basis of national origin was in large part because on the labor side, they saw immigrants as, in some ways, coming from specific ethnicities, unable to organize or unable to build a solidarity with the labor organizations. And employers who had actually used immigrants to break strikes for many years suddenly saw that Eastern and Southern European immigrants may actually be prone to striking as fear of communism and anarchists started to rise. There are a little bit more in this area, but I'm going to move on a little bit quicker in the historical analysis. The third one is actually with regards to individual rights. And as I said before, the 1960s and 1970s sort of saw a shift of thinking about labor employment as a matter of individual rights. Now, in some ways, the connection is very easy. In 1965, when we repealed the racial quota and we essentially sort of reopened our doors to immigration, that was actually itself a direct response to the civil rights era when we saw racial discrimination as essentially problematic. But I want to say also hidden within that specific area law, which is actually different from other countries, is also another conception of rights within the immigrants itself. There's a lot of critique that the United States is so unique in that our immigration system is almost primarily founded around family reunification. Very few countries have that, right? But in some ways, family reunification is hard to get rid of because it's seen as a right? It's a right of the individual in order to bring a family member in. But I also want to go beyond the 1965 Act, and I want to talk a little bit more closer to home about the employment restrictions in 1986. This is what we deal with today, the fact that employers actually have to check numbers. I want to suggest that this, although it seems to be commonplace today, actually was a substantial expansion of the federal government's involvement in immigration regulations. And then I want to suggest that it was only possible because the federal government at that time had already expanded the extent to which they were regulating employment in all sorts of different contexts. And what is interesting about the rights context, too, and I want to sort of posit this as well, is that within the rights, and I can't go into a lot of the literature on the rhetoric of rights and how that operates, but one thing is interesting is how it's also changed the way we talk about immigration regulations. If you recall the case of Decanis versus Bika, excellent case. One part that's actually not always noticed in that case is actually, although the case was about a state and the federal government with a matter of law, who really initiated the lawsuit was actually a migrant worker who said that because their employer were hiring undocumented immigrants, it violated his right to fair wages. Right? So in some ways, by creating a rights regime, you also have the counter-rights regime. Right? If on the one hand, by creating a right to certain employment conditions, the government can step in and say, and therefore there are also no rights to employment, right, and regulate that. On the other hand, if you grant rights to certain bodies of workers, their rights can also be asserted against other workers as a means of saying, my rights are being violated by your rights. Now, this is actually quite common. One thing that's very interesting in the Arizona law that was at issue in Chamber of Commerce's Whitting that I read through, that I found interesting, was that it actually sets up a system much like our individual rights system where the primary enforcement mechanism is other employees. Right? The process starts with an employee filing a complaint through the state government against a certain employer. And then it says that the government must, right, it shall, the Attorney General shall investigate and therefore determine whether or not there was in fact a violation. But I do think that this also substantially twists the way we think about immigration in our conversation today, right? Because what it does suggest is that instead of seen as a broad macroeconomic issue or a structural issue between different components of the economy, we're starting to see as a battle between competing individual rights, right? My individual rights not to have my wages suppressed, your individual rights in order to work. I am short on time, but I do want to say something about the current debates. One thing that I want to suggest about adopting this framework as well is it also applies to how we think about how we're going to reform immigration going forward. And one thing that struck me, and it was actually in the first panel when Chris Kobach made this argument, was that actually there's several different positions in which you can take if you care about labor and employment. Let me just go through them, okay? So you often start out, if we were on a circle, right, with the first argument and say, we're really concerned about wages and working conditions in the country, therefore you should block the borders. And then another individual will come up and say, well, no, if you're really concerned about wages being too low or working conditions, why don't you just raise wages as a matter of regulation or raise working conditions as a matter of OSHA, right? I mean, why don't we do that? To the extent that then that kicks out undocumented immigrants, because if everyone's getting paid higher and you can't pay lower wages, then it's an indirect way of regulating immigration without closing the borders. And then another individual will step in and say, well, no, if you're really concerned about labor and working conditions, what we need to do in order is to regularize the labor market, right? We need to grant some sort of amnesty so that we can bring this shadow market into play so that they can collectivize and organize and unionize and have the negotiation bargaining that we always think is possible. Now, in the immigration debates, what happens is these three arguments just kind of float around, right? Because actually you're sort of, at least for the participants, it seems like you're talking across each other, right? You're sort of focusing on the different thing. And I think that's what we had today when Chris Kobach said, if you're really concerned about the working wages in Kansas and in Nebraska, what you should be doing is closing the borders. But what I want to suggest is that what is actually at stake in this debate, why that debate can't get reconciled, is because we have conflicting ideas about labor and employment. Right? For the individual who feels that, no, we should just close the borders, what they want to say is, I don't want to actually have the government step in to increase substantive rights for workers or worker conditions. Right? For those who go the other tack, they want to increase substantive rights for workers and working conditions, but don't think macroeconomic concerns is the biggest, is the only way to approach it. And again, with amnesty, I think hidden within that, especially as the AFL-CIO, the SEIU, and many unions are getting involved in favor of amnesty, they see it as a means of regularizing a workforce in order to have that collective bargaining. But I think for individuals who don't think that's a good idea in the world of labor and employment, they resist that as well. I guess to sort of take a step back, but I know I skipped some things I promised you. I hope you won't hold it against me. But I think to take a step back, what I want to suggest here is that in order to resolve the broader immigration debates, we may need to have a serious discussion about labor and employment in this country. That's not easy. And the interesting thing is a lot of that is happening at the state level, right? But instead of just seeing immigration as sort of self-contained or immigration as affecting labor and employment, it may be that by having this other conversation, we can not only resolve debates here, but it could actually open up a much more broad arena of possibilities for which to address the immigration issue than just to rely on the DHS. Thank you.